Ladies and gentlemen, good day and welcome to the new Foreign Exchange Regulations Impact on Foreign Investments into India conference call. As a reminder, all participant lines will be in the listen-only mode, and there will be an opportunity for you to ask questions after the presentation concludes. If you need assistance during the conference call, please signal an operator by pressing star then 0 on your touchtone phone. Please note that this conference is being recorded. I now hand the conference over to Ms. Pratibha Jain. Thank you, and over to you, ma'am.
Thank you, and welcome everyone to our webinar on the new foreign exchange regulations and its impact on foreign investments into India. As you may be aware, the TISCO regulations is the primary regulation for foreign investment into India, and along with the FDI policy, it provides the overall guidance from the government, which provides overall guidance from the government for foreign investment. It generally follows the principle that whatever is not permitted is prohibited, and therefore we need to read these regulations threadbare every time there is a proposed change, because it has a significant impact on how foreign investors invest in India. Before we deep dive into the recent amendments, let me just quickly summarize the various routes for foreign investment into India. Broadly, we can categorize equity and quasi-equity investments into 3 routes: the foreign direct investment, the foreign portfolio investment, and the foreign venture capital investor regulations. The FDI investments traditionally been investments in unlisted securities. The foreign portfolio regime was for investment in listed securities, and FVCI was a liberalized route for investment in certain key sectors. Of course, this is just a general route. There were certain, exceptions in each of that category. The recent amendment basically aimed to give effect, as announced by the government, to the Mayaram Committee report, which was penned down in 2014 and had suggested that instead of classifying investments in listed securities based on the current system of regulations, we should rather classify them based on percentage holding of the investors. So minority investment below 10% to be considered FPI, and anything above 10% to be considered FDI. And this was mainly to bring Indian regulations in line with the global standards. While the amendments, as proposed by the Mayaram Committee report, are aimed at bringing Indian regulations in line with international standards, there are Indian nuances that make implementation of the proposed amendments cumbersome and leading to possible long-term complications. Unlike such jurisdictions where you have this classification, we have multiple regulators regulating foreign investment in the Indian securities. Today we have listed securities regulated by SEBI, unlisted securities regulated through the FDI policy and TISCO regulations by RBI, DIPP, and to a certain extent Ministry of Finance. Now, with the proposed amendment, there is going to be an added layer of RBI and government directly looking into policies for listed securities, which means SEBI regulation, FDI policy, and TISCO regulations will have to be read in tandem to determine rules regarding investing and trading in listed securities in India. While RBI has released TISCO regulation amendments, we still have to wait for SEBI to amend its regulations to fully understand the proposed changes. With that, I will quickly summarize the key changes proposed. The most significant change as proposed in the Mayaram Committee report was the definition of FDI and FPI. As per the change, the foreign portfolio investment now means any investment made by a person resident outside India, where such investment is less than 10% of Indian listed company. And foreign direct investment means investment by a person resident outside India in an unlisted Indian company or in 10% or more of a listed security in an Indian company. In addition, in case of total holding of an FPI, if it increases to 10% or more of the total paid up equity capital or of a listed security, or 10% or more of either debentures, preference shares, or share warrants issued by an Indian company, the total investment made by the FPI shall be reclassified as FDI, subject to the conditions as specified under the SEBI regulations and RBI in this regard, which, like we said, is still to be notified by SEBI. Transfer of capital instrument on a recognized stock exchange by a person resident outside India is now required to be reported by such person in Form FCTRS to the authorized dealer bank. In addition to the changes on FDI and FPI definitions and related changes, there's been relaxation on NRIs being able to sell the capital instruments as defined under the regulations to person resident outside India. One change that Mayaram committee report had suggested that has not yet been made is with respect to FPCI regulations. We hope that whenever those changes are announced, it will be in the nature of liberalizing the current 9-sector restrictions rather than merging the regime with the FDI regime as proposed by the Mayaram committee report. On that note, I will ask my colleague Ruchir to elucidate on the key changes.
Thank you, Pratibha. I think these regulations have clearly given a new dimension to the way we looked at the TISPRO regulations, or so we call them, in as much as they have kind of allayed a lot of ambiguities. The entire schedules, etc., have been pretty much aligned, and there has also been an attempt to achieve some degree of synchrony between the various other legislations. So I think without spending too much time on generality, I'll quickly move on to the specifics. Starting with the definitions, I think two, three definitions are critical, and I'll just read that out for everyone's benefit. One new definition which has been added is that of foreign direct investment, which was not defined till now. It says that foreign direct investment means investments through capital instruments. Capital instruments is broadly how the term capital was defined. I'm not going into the nuances of it. By a person resident outside India in an unlisted company or in 10% or more of the post-issue paid up capital on a fully diluted basis of a listed company. So essentially what they're saying is that if you're investing less than 10%, conceptually it cannot be FDI. And if you're investing more than 10% of the paid up capital on a fully diluted basis, that will be FDI. Now, the definition of another important definition is that of foreign portfolio investment, which says foreign portfolio investment means any investment made by a person resident outside India. Please note, it does not say foreign investment means any investment made by a foreign portfolio investor. It simply says foreign portfolio investment means any investment made by a person resident outside India through capital instruments where such investment is less than 10% of the post-issue paid up share capital on a fully diluted basis of a listed company or less than 10% of the paid up value of each series of capital instruments of a listed company. The definition, then they have added another definition for who is a foreign portfolio investor, which means foreign portfolio investor means a person registered in accordance with the provisions of the SEBI regulations 2014. Now, I think the takeaway from these three definitions is if you are investing in an unlisted company, then any investment which you are making will qualify as foreign direct investment. If you are investing in a listed company, you need to see the threshold at which you are. If you are less than 10%, then conceptually looking at the definition of foreign portfolio investment, you could be qualified as a foreign, your investment could be qualified as foreign portfolio investment. If you are more than 10%, then your investment could be qualified as foreign direct investment. I think one of the critical changes, as Pratibha mentioned, the government has clearly accepted the recommendations of the Mayaram committee report and moved from an investor specific regime to an investment specific regime. So it does not matter whether you are really registered as a foreign portfolio investor or not, so long as your investment is less than 10%, which means essentially you're not having any kind of controlling rights and things like that, or at a conceptual level you are holding such a minuscule right that it is actually seen as portfolio investment, then that investment will not qualify as as a foreign direct investment, and the conditionalities that are generally applicable to foreign direct investment should not apply to such kind of portfolio investment. I think the other change which is relevant is the way in which the schedules have been realigned. Schedule 1, which under the previous FEMA 20 regulations, as we call it, or also TISPRO as you call it, was always referred to as the FDI schedule or foreign direct investment. And Schedule 2 was for foreign portfolio investors or FPIs. They have changed the construct of Schedule 1. Now Schedule 1 is not just FDI. So if you see the heading of Schedule 1, it says purchase/sale of capital instruments of an Indian company by a person resident outside India, which means that they are again trying to generalize here that it does not matter whether it is FDI or FPI, anyone can make an investment over here, and based on the investment threshold of less than or more than 10% threshold, your qualification criteria will be decided whether you are a direct investor or a portfolio investor. Schedule 2, on the other hand, talks about investments to be made by a registered foreign portfolio investor. Schedule 2's heading is purchase/sale of capital instruments of a listed company on a recognized stock exchange in India by a foreign portfolio investor. So what's the change really? If you are wanting to invest on the floor of the stock exchange, you want to buy on the floor and you want to deal, your dealings are largely on the floor, then you will have to have a foreign portfolio investor registration, because FDI investor which is not registered as a foreign portfolio investor will not be permitted to buy on the floor. An FDI investor can of course sell on the floor. That scenario does not change. That was the case earlier and that remains. But an FDI investor is not permitted to buy on the floor. Therefore, if you really want to buy on the floor, you will need a foreign portfolio investor registration. A foreign portfolio investor naturally is permitted to buy on the floor, sell on the floor. That remains the same. Another important change that Schedule 2 makes is that if you cross the 10% threshold that is permitted, foreign FPI, sorry, if you cross the 10% threshold that an FPI entity is permitted to invest in an Indian company, then you automatically qualify as a foreign direct investor, and to that extent your sectoral conditionalities and caps, etc., whatever are relevant to that sector will apply. If after exceeding 10%, if suppose you go back to a less than 10% threshold, you still remain an FDI investor, because once you exceed and you become an FDI investor, then you continue to remain an FDI investor even though you've ultimately reduced your threshold. So I think what they've basically done is that they've tried to, of course there are a few ambiguities here and there, and this will get clarified. I think one of the biggest questions that is coming up is that if an FPI can actually not acquire more than 10% in an Indian company, then where is the question of FPI becoming an FDI? And I think to that extent, probably from what we understand, there is some kind of discussion, and that will also be liberalized, that an FPI may be allowed to invest more than 10%, which was also the recommendation that was given in the Mayaram committee, that it should be seen on an investment specific threshold, and therefore doing away with the need. So let's see how SEBI comes up with with some of those changes. So with that, I think that's the broad set out of the of the new FPI and the FDI regulations, and how you can actually make portfolio investments in listed companies without getting without being a registered foreign portfolio investor. But I think this will have significant implications from a deal making perspective. So Simon, maybe you could just tell us from a deal making perspective, how do you see this? I think a lot of ambiguities, and why don't you tell us how this will play out?
Thanks, Ujjwal. So I think the first sort of implication, as you rightly pointed out, is that a registered FPI that holds 10% or more, if that entity acquires more than 10%, it becomes an FDI investment. However, having said that, we still need a corresponding amendment to the SEBI regulations for both these investment routes to be read, in conformity with each other. Failing that, there is an ambiguity today. If you look at Schedule 2, and I will call it Schedule 2 because those are investments by registered FPIs. The first part of the schedule talks about the FPI plus the investor group. However, the second part of the schedule does not talk about the FPI plus the investor group. And perhaps, and the connotation of this is that if an FPI and its investor group holds more than 10%, does that become FDI, or is it linked to the FPI holding 10% alone? I think perhaps the intent was to cover the FPI plus the investor group holding 10% or more, because of how the regulations in Schedule 2 really read. And therefore, perhaps the intent would be to see that the registered FPI and its investor group, if it holds more than 10%, the total investment would be an FDI investor. The second implication is with respect to P notes. Now, because of the definition of capital instruments, and capital instruments being linked to securities issued by the Indian company in the fully paid up equity share capital of that company held by that entity, P notes, which is a derivative instrument holding only economic benefits and not covered under the TISPRO regulations, do not seem to be within the threshold, or do not come within this limits or the caps. And therefore, what that would mean is that if an FPI entity holds an economic investment through the P note route, that should not be counted towards the aggregate threshold in determining whether the FPI, the registered FPI entity, holds FDI or just FPI. Another sort of consequence is that if the registered FPI converts gets its shareholding converted into FDI, the threshold for P notes becomes sort of reopened, and therefore perhaps the registered FPI can hold additional 10% through the FPI route through the P note route, because that today is covered by SEBI and not regulated by RBI. Therefore, we presume that the SEBI regulations will have to be amended to accommodate and to ensure that there's conformity amongst regulations. But until such time, there is an ambiguity here. The next aspect that comes into, or the next implication would be, it's always been known that an FPI entity that is a registered foreign portfolio investor cannot sell instruments that it has purchased through the PIS route off the floor of the stock exchange. However, if it converts its FPI holding into FDI and becomes therefore an FDI holder, holding more than 10% in the company, perhaps that is not a restriction that it would be subject to in this context. And therefore, there could be a situation where a registered foreign portfolio investor purchases 9.9% on the floor of the stock exchange under Schedule 2, acquires maybe a little bit more, increases its shareholding to beyond 10%, converts its entire shareholding into an FDI investment, and is then able to transfer those securities off the floor of the stock exchange because as an FDI holder it can. I think the next sort of connotation is that Schedule 2, as it reads, is a schedule only for registered foreign portfolio investors. Since now a registered foreign portfolio investor can also hold FDI, the registered FPI can perhaps do control deals on the floor of the stock exchange, which is something not permitted for unregistered FPIs or unregistered foreign entities who can only purchase on the floor of the stock exchange once they have acquired control. So that perhaps is another implication of these regulations. I think in terms of the FDI holdings and the non-registered FPI holdings, I think perhaps the regulations do miss out the concept of an investor group in a non-registered FPI investment, wherein it looks like the regulations only target the entity specifically and not the investor group. So if you look at the definition, the explanation as to what would constitute an FPI investment, where it talks about investor group, is limited to registered FPI holders and no other investor. And therefore, that perhaps is an ambiguity that the regulators might want to clarify, because even a non-registered FPI holder through its investor group should not be able to cross the 10% limit and still continue to call that an FPI investment. So I think with that, Nischal, maybe if you can discuss the implications to other laws, because because of the touchstones here.
Sure. So, as Ruchir and Pratibha rightly mentioned, the idea of the government has been to simplify the foreign investment regimes. And if you see the way government has simplified the foreign investment regime since in the last 4 to 5 years, earlier, as all of you know, there was a concept of foreign institutional investor, there was a concept of sub account, there was a concept of qualified foreign investor. All these three types of investors were merged into a foreign portfolio investor in 2014. The next step which the government took in 2015 after the Mayaram committee report came out was to club the FDI and FPI limits within the sectoral cap limits under the FDI policy. So if you see in 2015, for example, take commodity exchange or power exchange, up to 49% foreign investment was allowed, where 26% was allowed for FDI and 23% was allowed for FIIs or FPIs. This limit of 26 plus 23 was not making sense in terms of fundraising by the Indian companies, because most of these companies were unlisted and FIIs were not anyways allowed to invest in unlisted stocks. So the 23% limit was going unutilized, because of which what the government did was to club both the FDI and FII or FPI limit to 49% and make it fungible between FDI and FPI. So the process had started long back to club various investment regimes to simplify it for the foreign investors, and the latest one being the new FEMA 20, which has been introduced, where the idea is now to change the policy stance from having policies based on the type of investor to having policies based on the type of investment, which is below 10% and above 10%. Now, if you see what could be the potential impact on other regulations, and obviously it's more of a guesstimate on what can change. I think one impact could be on the CCI or the Competition Commission of India, where currently foreign portfolio investors, when they make acquisitions under Section 6 of Competition Act, they get the benefit of reporting the investment within 7 days from the date of consummation of investment. Now, it would be interesting to see, given that under Schedule 2 of the new FEMA 20, FPIs have been allowed to even cross 10% limit. In which case, if an FPI acquires, let's say, 7 or 8% on the exchange under FPI route, and then they jump to, let's say 12% or cross 10% where the investment becomes FDI, can CCI come back and say that the intent was to acquire more, and instead of reporting it within 7 days, you should have come to me before even acquiring the 7%? So it will be very interesting to see how CCI interprets this on transition from FPI to FDI, whether it was already intended when the earlier 7% was acquired under the FPI route, and whether the approval should have been taken prior to consummating the transaction or post. I think the other thing which and I think this will become important because just as the way the control definition has been aligned across various legislations, so what the government has done, if you see in the last again 4 to 5 years, they have aligned the definition of control under FDI policy, under Companies Act, under Takeover Code, and under Competition Act. So all the legislations pretty much have the same definition of control. Now, if the overall idea is to consider the concept of foreign portfolio investment as below 10% and foreign direct investment as above 10%, the same concept should apply across all legislations, where the regulation should be liberalized for foreign portfolio investment when it comes to taking approval or adhering to certain restrictions, and if it is a foreign direct investment, then the same can be dealt with more stringently as compared to a foreign portfolio investment. The other major change which we will see would be under the SEBI FPI regulations, and again, there are a lot of ambiguities in the way the new FEMA 20 has been drafted. And one of the things which we need to see is, if the government's intent is to move towards an investment-based regime as compared to an investor-based regime, is there really a need to have a foreign portfolio investor registration in the first place? And if that's the case, then there will be drastic change in the SEBI FPI regulations, because then it won't be investor based, it will be investment based. Other important thing which will need to be looked at is, as Simon mentioned, on the investor group. The concept of investor group as per SEBI FPI regulation is limited to the FPIs within the same group, or the foreign registered FPIs within the same group. But if government intends to even consider non-registered FPIs, if they're investing below 10% as foreign portfolio investment, whether SEBI FPI regulation will also need to be changed to factor non-registered FPIs who are part of the same group, so that overall the spirit of the regulation of not crossing 10% for foreign portfolio investor is taken care of. I think the other important change which we might see depending on how things pan out, because we are expecting clarifications from the government on some of the issues which we raised on the panel. But one of the things would be, currently under the tax laws also, there are certain preferential benefits which are available to registered foreign portfolio investors. Now again, if the concept of registered foreign portfolio itself is phased out in long run, then there may not be any need to have some of the exemptions which are currently available. So broadly, I think these are the key changes which we see, which will need to be made going forward to some of the other regulations to take care of the changes which have been made under new FEMA 20.
So Simon, I think coming to reporting, which is I think now becoming a little complex to understand, because earlier there was reporting under each schedule, and therefore we used to say, okay, if it's FDI, it's FCGPR and all there. Now they have, instead of putting in separate schedules, they have put reporting requirements within the main regulation itself, and therefore giving a perception that probably the same reporting standards would be applicable all throughout. So you want to just give us a perspective on how will the reportings work, particularly in context of listed FPI investments in FDI listed space?
Sure. So I think the two main sort of reporting requirements are the FCGPR form for issuance of securities and the FCTRS form when you transfer securities. And traditionally, it has always been done through the FTI route. there was no real specific reporting required from an FPI perspective. An FVCI, there were changes brought about to suggest that the FVCI investment must also be reported. However, by the Indian company. But however, there's been a little bit of a concern there because the form and the modality is still not crystallized, leaving a bit of a problem in the procedure in terms of how do you actually make this reporting. But going back to how the new FEMA talks about this, is that they have now clubbed reporting for all investors under one bucket. So it the reporting, like you said, Richard, is part of the main regulation, and specifics are made where required. I think there is an ambiguity, however, whilst the especially in the FCGPR form. Now, the FCGPR form continues to be required to be made only for FDI investments. And as per the definition, this would mean for any unlisted company as well as for any investment beyond 10% in a listed company. Less than 10%, if it's a Schedule 1 or a Schedule 2 investment, it does not seem to be a reporting requirement by the company. And an FCGPR is a form that reports the receipt of the receipt of money by a Indian company that is issuing securities. So therefore, for a Schedule 1 investment or a Schedule 2 investment of an investment that is less than 10%, by an investor that is not FTI, does not seem to be there does not seem to be any reporting required. Now, this doesn't really change much for a registered FPI, because a registered FPI, custodians typically, took the onus of making reportings to the Reserve Bank of India and SEBI as required under those regulations. So, investments by registered FPIs would still perhaps be reported through custodians. That leaves us with the problem of unregistered FPIs wanting to make an FPI investment. There is an ambiguity in terms of how this needs to be reported, whether it's going to be the duty of an authorized dealer that consistently reports incoming investment into the country to the Reserve Bank of India, or there will be another amendment to this regulation requiring the company itself to make a specific reporting of such investments received, because it's unlikely that the Reserve Bank of India would not want to have this reported separately. The next sort of concern or issue is the FCTRS form filing. Now, the FCTRS form filing, again, like I said, was only limited to investments made by FDI investors. Even if you were selling on the floor of the stock exchange, because an FDI investor could always sell on the floor of the stock exchange, though it could not purchase, and it still cannot purchase today. The FDI investor had to make this FCTRS form filing when it sold securities to a resident investor. So an NR to R, you required to make that reporting. An R to an NR as well required to make that reporting if you are doing it under the FDI route. The FPI route, which was traditionally only done by registered foreign portfolio investors, did not require this form to be filed. And I suppose the thinking was that the custodians would make the same filing with the Reserve Bank of India and SEBI, as the case may be. However, the law now has been changed to require any person resident outside India selling on the floor of the stock exchange, to make this FCTRS form filing. And what's new about this is that whilst any other form of FCTRS that is done under the FTI route, or that is done for a non-listed company, needs to be, the onus is on the resident Indian to make the filing. When it comes to a listed company and when it comes to a non-resident selling on the floor of the stock exchange, the onus is on the non-resident entity. And therefore, even an FPI or a registered FPI holder, or even any other investor making a foreign portfolio investment that sells on the floor of the stock exchange will need to file the FCTRS form, with the authorized dealer. Now, we expect corresponding changes in the eBiz portal, because we know that right now the onus and the forms are tuned, or accommodate only filing by the resident entity and not a non-resident entity. So perhaps corresponding changes will need to be made. But this is a procedural concern or procedural issue that will have to be followed for all registered as well as non-registered FPIs that make investments on a regular basis.
So Nishith, I think once we've sorted out this FDI, FPI, which is I think the biggest chunk, uh, I think the question to you is from a downstream investment perspective. I think there's been some clarity.
Mhm.
So do you want to just share thoughts on that?
Sure. So I think, as all of you are aware, the downstream investment guidelines were introduced under the FDI policy in 2009. What it essentially said was that if an Indian company, which is either foreign owned or controlled, makes any downstream investment, then the same will be considered as indirect foreign investment in the company in which the downstream investment has been made. Now, one of the issues which came up on account of the way the FDI policy was worded till April 2015 was that the definition of indirect foreign investment uh, did not specify the type of instruments which will be considered as indirect FDI for the purpose of FDI policy. The language used in indirect foreign investment was any acquisition or subscription by a foreign owned or controlled company will be considered as indirect foreign investment, and hence there was an ambiguity on whether instruments which do not get categorized as capital as per FDI policy, which means instruments which are neither equity nor CCPS nor CCD, uh, can a foreign owned or controlled Indian company make those investments? In FDI policy 2016, this clarification was issued by the government. This was clarified in the FDI policy of 2016, where the definition of indirect foreign investment was changed to specifically mention that the indirect foreign investment will be considered if the downstream investment is in the capital of the downstream company. And capital, as has been defined, only means equity or instruments which are mandatorily convertible into equity. Followed by the FDI policies of 2016, there was RBI FAQs. There were RBI FAQs which were issued on February 13, 2017, where again RBI clarified that uh, investment in non-FDI compliant instruments will not be considered as downstream investment. So at least from a instrument perspective, there is a lot of clarity that a foreign owned or controlled company can make investment in non-FDI compliant instrument without any prior regulatory approval, and that's also been the industry standard which has been followed across the transactions. Now, what has been clarified is that earlier the issue which used to be faced was that when a foreign owned or controlled company had to transfer shares in the downstream company to an Indian resident or to a non-resident of India or to another foreign owned or controlled company, there was no clarity on the pricing requirements that should be followed or what type of reporting need to be made, especially in the form of FCTRS. The new FEMA 20 regulations have clarified uh, that in all the three situations, first one being when a foreign owned or controlled company transfers shares to a non-resident of India, then there is a requirement to file Form FCTRS. When a foreign owned or controlled company sells shares to an Indian resident, then there is a requirement to comply with the pricing guidelines. And the third situation where a foreign owned or controlled company sells shares of a downstream company to another foreign owned or controlled company, then there is no requirement either for FCTRS or pricing. So this clarity at least has will at least make deal making simpler from a compliance perspective, because typically what we have seen is that in situations where an FO foreign owned or controlled company is involved in a transaction, the authorized dealers are always struggling to take view on whether the reporting needs to be made, whether pricing requirements need to be made. Then they go back to RBI to check, and there has always been a lot of confusion around that. fortunately, with this clarification, hopefully, going forward, this confusion should not arise. So, other than downstream investment by companies, the concept of downstream investment by AIFs in which still applies, where as long as the AIFs are owned and controlled by Indian resident manager or Indian resident sponsors, and the sponsor and manager are also controlled by Indian resident citizens, any downstream investment by AIF will be considered as domestic investment. Even in a situation where the AIF is foreign owned or controlled, the view still remains that non-FDI compliant instruments the AIF can still invest in the non-FDI compliant instrument. This is in line with the same interpretation which is taken for downstream investment by foreign owned or controlled companies. So broadly, these are the changes as far as downstream investments are concerned.
Right. So I think there are a few minor changes which actually in deal making mode become quite a pain. They seem minor in the larger scheme of things, but otherwise these can be quite difficult to handle at times. For instance, till now, any transfers from an NRI or a PIO to another non-resident required prior approval of the Reserve Bank of India. Now, either you're an NRI or worse still, if you were a PIO, which means person of Indian origin. So even if you were married to an NRI or an Indian resident, or at one point in time your fathers or your forefathers were actually Indian residents, you became PIO, which initially was meant to be beneficial for you, and there were certain entitlements given to you, came to bite back and kind of rub the wrong way, because any transfers from an NRI or a PIO to another non-resident required prior approval of the Reserve Bank of India, which could sometimes be time consuming. Although we must admit that for the past 2-3 years we've been seeing RBI to be very proactive. In fact, the moment we used to send it, the moment we used to apply, the RBI officer would himself call and say, "Sir, I've received your application. It's going to take, let's say, 3 weeks or 4 weeks, and now you submit so and so documents." And within 3 weeks we were getting the approval. But still, I think it was a process which was pretty much unnecessary. And these set of regulations kind of do away with those requirements, and they clearly say that transfers from an NRI to another non-resident shall be permitted under the automatic route. That's one change. Second is in case of pledge. As you would know, pledge of an Indian company shares by a non-resident was not ordinarily permitted. It was permitted in case of pledge was permitted only to an Indian resident if the Indian resident was a bank, which was always a bit of a challenge, because NBFCs are today playing a very significant role in some of the promoter financing or other kind of lending transactions. So there was a need that was felt that even NBFC should be allowed. And in fact, they were pretty prompt. Even in recent past, we applied in one of the situations pledge in favor of an NBFC, where a non-resident wanted to pledge his shares to an NBFC, and that approval came within about 2 weeks. So they were quite prompt, but still it was an approval requirement. Now under the new regulations, that pledge to an NBFC is permitted under the automatic route. Pledge by a non-resident to another non-resident was permitted only if the pledgee was a bank. But while that has not changed, a significant change which has happened is that there is and so one of the restrictions, when a non-resident was pledging to an overseas bank was that the funds could not be brought into India. Now, in most cases, the funding would be required for Indian operations, or to buy the shares or something like that. So that was seen as a bit of a challenge. Now, that regulation per se, I think it's a little ambiguous, because the restrictions of funding not brought into India were contained not in the main TISPRO regulations, but really under what we call as Circular 57. These regulations also tend to say that any kind of pledge offshore will be subject to the regulations made by RBI from time to time. I think it remains to be seen whether even under the new test pro regulations the circular 57 remains applicable, or RBI relaxes that and says whatever regulations are they are contained herein, and this is on a prospective basis. Therefore, Circular 57 will be overruled by the set of regulations. But on a conservative basis, we still believe that any pledge in favor of an overseas bank and any funding raised therefrom cannot be routed into India in light of Circular 57. Third, and a very important change from a cash upstreaming perspective, is the payout that you could make on fully convertible and compulsorily convertible preference shares and compulsorily convertible debentures, so CCPs or CCDs as we used to kind of commonly call them. There was a although CCDs never had a interest threshold, but CCPs had a threshold under Schedule 1, which said that an Indian resident will not be, an Indian company cannot pay out more than SBI prime lending rate plus 300 basis points, which came to about 16 or 17% odd, under the current lending environment, to the CCPS or the CCD holder. That restriction is conspicuous by its absence from the regulations, and therefore we are inclined to believe that the restriction on the interest rate or the dividend rate that could be paid on convertibles, whether debentures or preference shares, is probably not there, which I think can be a significant leeway for structuring some of the deals. Because India is a high yield economy. In certain cases, 20% is also considered arm's length. So you could possibly pay a significantly higher amount of payout on some of these instruments. I think another very important change is from the perspective of structuring rights issues. Now, as many of you would know, that from a Companies Act perspective, people were structuring many of the preferential issues as rights issue only to avoid the hassle of going through the preferential issue. But from a FEMA perspective, we always believed that even a rights issue should be subjected to the pricing restrictions. There was always a provision under FEMA that exempted rights issue from the regular pricing as was applicable in case of issuance of shares to a non-resident. And I'll read that out just for your benefit. It was there in the previous regulations also, which remains here. It's under Regulation 6 of the new TISPRO, where it says under 6.5, in case of an unlisted company, the rights issued to persons resident outside India shall not be at a price less than the price offered to persons resident in India, which means that the fair market value threshold, which was applicable to issuance of shares to person resident outside India, was not applicable in case of rights issue. And we also maintain that, so long as it was a genuine rights issue and not really renunciation. But these new regulations add a very interesting twist to rights issue by saying, and I'll read out. It says in the explanation that the above conditions shall also be applicable in case a person resident outside India makes investment in capital instruments other than share warrants issued by an Indian company as a rights issue that are renounced by the person to whom it was offered. Therefore, there can very well be a situation where a company actually makes a rights issue to its shareholders, but the shareholders renounce that issue. As you know, under the Companies Act, then the board has the power to allocate the unissued quota to third parties, and therefore it could issue it to another set of non-residents who were not shareholders. In such a situation, till now we always maintain that you should on a spirit basis still comply with the pricing regulations, but which you might still, but the regulations at least give you enough leeway today to say that if it's a renounced rights issue, then the board could actually issue shares to people who are not its shareholders at a price which may not be in conformity with the regular FDI pricing norm, that is fair market value. The only requirement is that you should make the same offer to the Indian resident shareholders also, if any. So I think that's a significant change, and I think that pretty much has to be seen on a spirit-based test. And we are not advising that you structure every preferential allotment as a rights issue to avoid pricing, but I think that's a significant significant leeway from a regulatory perspective. But it should be seen in the right spirit, and only genuine rights issues should be undertaken. So I think that's.
So I think there are two other sort of changes that maybe we can sort of dwell in. One is in terms of the type of instrument that can be issued now, where an Indian company wants to issue securities for a swap of shares. Now, that was something that was permitted by the Reserve Bank of India. Previously, you required an approval, but the concern in how this has been drafted is that it suggests that the Indian company may issue capital instruments to a person resident outside India against a swap of capital instruments, if, of course, the Indian industry company is engaged in the automatic sector. Now, the use of the word capital instruments, because of the way it's defined, may seem to suggest that a swap of shares is only permissible vis-a-vis Indian or vis-a-vis sort of securities issued by another Indian company. So the investee company, the primary investee company, can only issue its securities to a non-resident investor, subject to that non-resident investor, swapping its existing Indian shares in another Indian company to the primary investing company. Now, previously, you could also look at swapping against shares issued by a non-resident entity, which means that if the non-resident entity had securities in an offshore company, that could also be looked at as a viable instrument for the swap. But these regulations seem to suggest that it is limited to Indian securities alone because of the way capital instruments has actually been defined. Another sort of change or something that has been done to ensure that the Companies Act and the FEMA today are aligned is that whilst previously share application money under the FEMA could be kept in for 180 days, the Companies Act required allotment to be done within 60 days, both from a preferential allotment perspective as well as the acceptance of deposit rules. But now the FEMA sort of aligns the two timelines, and the share application money must be returned within 60 days if the securities have not been issued. So that's something that has been reconciled between the Companies Act and the TISPO. So I think that's it from these regulations. I think
big changes.
Yeah.
I think Pratibha can just Pratibha, if you have any closing comments, and then we can take the questions which we've received on email, and then open the floor for any other questions on call. So Pratibha, you want to just make any closing comments?
Sure. So, I just want to make one caveat. While we have interpreted the changes based on generally accepted norms of legal interpretation, as we've stated in our discussion, we are still waiting. It's very clear that SEBI will have to come out with, the clarifications or changes in the FDI regulations or both. To implement some of the changes made in the TRISPRO regulations, and also to put in some procedural norms with respect to certain changes. And, till we have that amendment clarification from SEBI, some of these points are purely based on our interpretation of the TISPRO regulations. So, we will have to wait and watch and see, how SEBI brings about and, what those amendments are from SEBI. We have been told that there was the intent to, in informal discussions with the regulators, that there was an intent to bring about the SEBI regulations changes at the same time as the TRISPO amendments. However, we still haven't seen those. It would, just as in terms of procedure, would have been better if both had been done in tandem, because it's difficult otherwise reading these regulations in isolation, as you've heard my colleagues talk about the various changes and the open interpretations there, specifically with respect to which is clearly the intent in terms of the foreign investors being able to now go beyond 10%. That was what the Mayaram committee report intention was. You allow foreign investors to go beyond 10%, which is the current restriction in FPI regulations. Anything less than % is FPI, anything more than 10% is FPI. Now, again, based on our informal discussion with the regulators, you cannot hold, the intent seems to be you cannot hold both an FPI and an FDI position in an entity. So if you hold less than 10% and then go beyond 10%, you will have to convert into FDI, and in that case, all your investment is FDI, and you no more hold an FPI investment. So that's what Michelle was referring to, change in terms of based more on investment rather than the investor classification. I think on that note, we would close the discussion for today and open it up for any questions. Ruchi, I think we have some questions.
Yeah, I think, yeah. So while we are taking some of the questions which have been emailed to us, I would request all the participants to send any questions that they have to the group ID FEMA Webinar 2017 at nishithdesai.com. I'll repeat that. That's FEMA, FEMA WEBINAR 2017 at nishithdesai.com. Pratibha, I think we can take the first question. I think you can take it up. The first question from Mahesh Mishra from JP Morgan Chase. I think you have the question, so you can take it up.
Sure. The first question is, the regulations advise that in case of increase of holding of an SPI to 10% or more of the paid-up share capital of a company, the total investment made by such an SPI in the said company will be reclassified as a foreign direct investment. Does this mean SPIs can now hold more than 10% in a particular security? And is that 10% limit, foreign ownership limit, not applicable anymore? So like I just mentioned a short while ago, our belief is that you can now, as a foreign investor, go above 10%. However, and this is your corollary question, that when you go above the 10% limit, the holding gets reclassified as a foreign direct investment. And for you to be able to hold more than 10%, you would need to have an FDI account. And so just having an SPI is not going to be sufficient. How procedurally that will be done in terms of transfer from your holding as an SPI to an FDI, holding from a custodian to direct reporting under an FCGPR and an FCTRS. I think those we will have to wait and see how SEBI comes up with those norms. I think that answers the second question in terms of if the client crosses the 10% holding, our holdings required to be moved to FDI account, which we believe should be the case. And in terms of the last question in this prong, are there any guidelines on this issue by SEBI or RBI? I think, again, based on our discussions, RBI has issued what they believe was required from their perspective under the TISPO amendments, but SEBI will be coming out with their procedural norms and any substantive changes under the FPI regulations.
I think the second question by Mr. Mahesh Mishra, I think, has already been answered because we have discussed the FCT as form filing, and therefore we will deal with the third question. Richard, do you want to take that?
I think the third question, Mahesh, you're having, and you could email us if we don't address any of that. But I think the third question that you're asking is that the regulations seem to restrict long-term FPIs from purchase of unlisted debt other than infrastructure sectors. Uh, I think that is slightly incorrect because there is no change under Schedule 5 to that extent. FPIs could purchase debentures or non-convertible debentures earlier, whether of infrastructure sector or otherwise, which they can still do now. Your second question is the regulations now allow investment by long-term FPIs in to be listed securities. I think that was also permitted from a debenture perspective, whether they are unlisted, to be listed, or listed. Schedule 5 investments always allowed, those kind of investments. Your third question is also the earlier circulars of RBI restricted FPI investments in unlisted securities with end use restrictions such as investments in land, capital market, etc. However, the new version does not have the mention of the same. Does this mean there are no end use restrictions applicable now? I think the restrictions on unlisted debentures, which an FPI could subscribe, such as restriction to invest in land or to invest in capital markets, were contained in a separate circulars. Those restrictions will continue to apply. That's the view that we take. Uh, I think the other question that we had
I think we
was
have two questions from Prachita Redu. I think the first question is, can a non-resident, which is not an FPI, invest less than 10% capital in a listed Indian company? If yes, under which route? I think this was dealt with by the panelist, but the view here is that if we see the definition of foreign portfolio investment, it talks about any investment made by a person resident outside India, and it does not restrict to only foreign portfolio investors. And second is Schedule 1 of FEMA 20 talks about an Indian company may issue capital instruments to a person resident outside India, which also includes, Indian company will also include a listed Indian company. So to that extent, the plain reading of the regulation suggests that even a non-FPI investor should be able to invest less than 10%. Having said that, there are enough ambiguities under the under the new FEMA 20, which suggests that one of the intentions of the government could be to just allow only registered FPIs to hold less than 10%, and one of the reasons why that view is also there is because there is no reporting requirement which have been prescribed for a non-registered FPI investor who invests less than 10% in a listed company. So while there is a requirement to report more than 10% investment through Form FCGPR, and there is a requirement for less than 10% by registered FPIs to report through custodians to RBI, for non-registered FPIs who are, let's say, FDI investors and are investing less than 10%, there is no reporting requirement which has been prescribed. So this is something which I think RBI will have to come up with some clarification on this issue. But pending the clarification, it looks like the intent is not to prohibit non-FPIs to own less than 10%. Second question is, can an unlisted Indian company issue share warrants anymore? And this is an interesting question, and as Pratibha mentioned, because there are multiple regulators who are regulating on the same aspect, there is some contradiction which is there in this. So if you see FDI policy, share warrants are eligible instruments and form part of the definition of capital. And what is mentioned is, as long as the share warrants are issued by the company as per the Companies Act, that's what is mentioned under FDI policy, which means if it's issued under Companies Act, even an unlisted company can issue the share warrants. As compared to that, under the new FEMA 20 regulations, the share warrants have been defined as those issued by Indian company in accordance with SEBI regulations. Now, which means that SEBI regulations are applicable only to listed companies and not to unlisted company. So the question arises whether the intent is to limit issuance of share warrants only by listed companies, or even unlisted companies should be included as per the FDI policy. So this is a classic case of FDI policy saying something different as compared to what RBI says as per the new FEMA 20. And obviously, since these are capital account transaction, one has to go by strictest interpretation. And since RBI regulations only allow share warrants to be issued by listed companies as per SEBI guidelines, uh, I think the way we look at it is the view should be it should be only possible under automatic route for listed companies to issue warrants.
I think the other question is from Kaushal Kapatia from Multiples Equity. Question number 1. In Schedule 2, the 10% limit of debentures is now applicable on all debentures and not only convertible debentures, as was the case in earlier regulation. What is the impact on NCDs held under the earlier regulations as FPI? How does NCDs convert into FDI? I think the position does not change. The debentures here are being referred to debentures which are listed under the ICDR, which really means convertible debentures. But non-convertible debentures were and continue to be governed by Schedule 5, and the provisions of Schedule 5 of the TISPRO regulations continue to apply, which means only a foreign portfolio investor can subscribe to these debentures. Question number 2, can the same entity do both investments, FPI and FDI, for different portfolio companies? We believe the restriction is only on not being able to hold both FPI and FDI in the same portfolio company. Please clarify. Yes, we agree. It should be possible to take different position, different portfolio companies, but within the same Indian investee company, it may not be possible to take FDI and FPI investments. You have to choose whether you are FDI or FPI based on your threshold.
So I think the next question is by Adarsh, and Pratibha, do you want to take this?
I think Adar's question is with respect to Regulation 3.2 under the new regulations that actually this is one of the changes we hadn't discussed, which is actually important, where it's now been stipulated that you can pay fine for late submissions of reporting of FCGPR or FCTRS. We did have a discussion, again, an informal discussion on this with the regulators, and confirmed the position, at least orally, that there would be no more a need to compound the non-compliance in terms of delays of making these filings, which will make the process much simpler, and the delays in terms of compounding and sometimes that exacerbating exits for investors getting simplified. However, the quantum of the fees, the schedule is still not being provided, and it's something that is being discussed, we understand, between RBI and the Ministry of Finance, and it's still pending.
Okay, I think the next question
Sorry, we are just...
is from Vasudev, whether transfer of shares by an FPCI to a resident FCTRS would be required. I think we discussed, there are the FCTRS form has been made uniform for any non-resident investor transferring to an Indian entity or an Indian entity selling to a non-resident, and therefore, yes, although previously an FPCI didn't have to make that form filing, the FPCI will now have to make that form filing based on the new regulations.
So, sorry, there was just this one very small question. We'll address this one and then open the floor for questions from others. This is from Reena Jalan from ILFS. Whether transfer of shares or debentures of unlisted company from a non-resident to another non-resident need any RBI approval? Are there any changes under new TISPRO regulations? No changes. Transfer from non-resident to non-resident will be under the automatic route without any pricing, as was the case earlier.
I think we can now open the floor.
Open the floor. So we will now open the floor for any questions.
Thank you very much. Ladies and gentlemen, on the audio bridge, if you wish to ask a question at this time, you may please press star and 1. The first question from the line of Archana Shastri from Dr. Reddy's. Please go ahead.
Yeah, good afternoon. I had questions regarding ESOP issued to foreign nationals. So we have issued Indian options and ADRs to foreign nationals. So we would like to know the reporting compliances and changes specifically from the new act to the old and the old act.
So I think with respect to ESOPs, there is a specific form which says which you have to submit called Form ESOP, which has to be done to the regional office of the Reserve Bank of India. We don't think this form is ready yet, and once it is, that will have to be filed. So there is a specific form that is prescribed for issuance of ESOP.
Okay. And is that form ARF applicable for issue of ESOP?
No, so the form ARF, it says an Indian company which has received the amount of consideration for issue of capital instruments, and where such issue is reckoned as FDI, you must, file the form ARF. So, at the time of issuance of the ESOP, perhaps no, but at the time of converting it into a FDI, yes.
Okay. Can we take the next question?
Yeah. We have the next question from the line of Prachi Lala from Citibank. Please go ahead.
Hi. I wanted to ask, you mentioned P notes, that how it will not be covered under the aggregate ceiling when we calculate the 10% breach or not. How has that changed from previously, and could you just explain that?
Sure. So previously, the P note today, the FPI entity could hold only 10% through the PIS route, and the PIS route also included an indirect economic interest through the P note route. So in 2014, the law changed to say that the FPI holding would not only mean, for the 10%, would not only mean the direct investment that the FPI and investor group had, but also any investment through the P note structure, and therefore that was sort of clubbed together to reckon the FPI limit in the registered FPI limit in the company. From a FEMA TISPRO perspective, they talk about capital instruments. Now, what the Schedule 2 talks about is if you hold equity shares or any capital instrument in the company, and only then, when you hold a capital instrument in the company, will the aggregate of the capital instruments held by the FPI plus investor group be taken together to see whether or not you cross the whether your investment is an FPI, a foreign portfolio investment, or is it an FDI, a foreign direct investment. And therefore, because an ODI instrument is not a capital instrument issued by an Indian company, the holding of the P note is not counted to reckon whether the investment is a PIS investment or a FDI investment.
Thank you.
Thank you. A reminder to our participants, anyone who wishes to ask a question at this time, they may please press star and 1. We have the next question from the line of Mahesh Mishra from JP Morgan. Please go ahead.
Yeah, hello everyone, and thank you for answering all my questions. Just on the third question, which I had actually asked with respect to the long-term investor. So if we refer the Schedule 5, which is there in the regulations, so it has Part A, which covers permission for FPIs, and Part E, which is specifically mentions of the permission to other non-resident investors for purchase of securities, which they have generally categorized for long-term investors like SWF, multilateral agencies, and other, basically all long-term investor category as such, which are registered with SEBI. So in this point, they have specifically mentioned that they can do in listed non-convertible debenture or bond issued by an Indian company. And the point E mentions listed and unlisted non-convertible debentures of infrastructure sector, which is, I think, the recent change which SEBI and RBI had allowed a separate carved-out limit for a long-term investor to invest in the infrastructure sector. So in going through this particular E section of the Schedule 5, what understanding I get is basically now they are restricting an investment by a long-term investor in an unlisted non-convertible or debenture or bond, except for the infrastructure sector. So I'm not sure if my understanding is correct. Maybe you can just put some light on that.
No, sorry, I missed the last part of your question. You're saying that this is for sovereign category. You're
Right.
saying that can you just repeat your question? I missed the last part.
Yeah. So I'll tell you. So what happened is, like, initially when the corporate debt limits were up, the FPIs were allowed to invest in corporate debt only in a listed security. Okay. Then later on, RBI and SEBI allowed the FPIs to invest in an unlisted securities, provided the end use restriction of the issuer that was land on other stuff. So that was the guidance which was given, which is applicable for all category of FPIs. They are not given any specific category who can invest in unlisted security and who cannot invest. But recently there was a separate carved out limit which was given for a long-term category FPIs to invest in listed or unlisted securities of a non-convertible debentures or bonds of an infrastructure sector company. Okay. So now the new regulation which is there, basically the FEMA 1, the section E, which speaks about permission to other non-resident investors for purchase of security. It talks about long-term investors which are registered with SEBI. And there they have said that if you refer point number D, it says listed non-convertible debenture bond issued by Indian company.
Correct.
So that means they cannot do an unlisted non-convertible debenture or bonds issued by Indian company.
No, that's not allowed for them. For the sovereign category, that's not allowed.
Okay, because
You could go under I. No. So there are two separate categories. Category A is for FPIs, for registered as FPIs. Category E may not be registered as an FPI. This is for multilateral agencies. For multilateral agencies, there's a function of there's a permission to invest either in listed under D or under to be listed under I, or if it is infrastructure sector, then then it can be unlisted. But pure unlisted is not permitted.
Okay, because see, just for maybe it might not be the exact one, but still, if we say there is a particular limit which is allowed in a corporate debt for a long-term investor, right? Which they have said that limit could be utilized by a long-term investor to invest only in an infrastructure sector, whether listed or unlisted, bond of that infrastructure sector. And SEBI and RBI had stated that apart from this, long-term investor can invest in the general category, which is currently allowed for all the FPIs. So if I refer to general category, in the general category, all the FPIs are allowed to invest in listed or unlisted corporate debt securities.
That's correct. So the same multilateral agency, your sovereign wealth fund, if it's a FPI category 1, can very well go under FPI category 1 and acquire unlisted.
Yeah, I think.
But if it is,
I think the intent could be that the same sovereign wealth fund could, if it is registered as an FPI, it can avail of the benefits under 1A, which is A to H, which is if you see, it's about 7 to 8 type of instruments it can invest. Whereas in E, there are at least 13 type of instruments it can invest. So the intent could be that for long-term investors, the number of instruments in which these long-term investors can invest would be more than any other normal FPI, which could be the intent. So a sovereign wealth fund could very well go under, if it's a registered FPI, and it can go under 1A, and it can make investment in unlisted entities.
I think his point is that for infrastructure sector, there's a separate carve out of the 10,000 crores within the NCD
Correct.
limit.
So they can use that.
Yeah, they can use it. But for that it needs to be
FPI.
Yeah, I mean you'll have to see if it is because if it's for non-infrastructure sector, you may not be able to go for the unlisted debentures. I think we can discuss this offline, because I think there are a lot of people on the call, so we will discuss this. Can we take the next question quickly, please?
Thank you. We have the next question on the line of Uday Singh from student Nansar University. Please go ahead.
Hi. So my question is regarding AIF investment restrictions. So under Schedule 8 of FEMA 20, Category 3 AIFs which have foreign investments are allowed to make portfolio investment in the basket of securities available to FPIs. So I want to know if the parent 24% investment caps which are applicable to
wherein if one FPI is allowed to invest up to 25% of Cat 3 AIF.
So, no, would these investment limits also be applicable to AIFs, was my question.
No, it should not. It should not.
It should not be.
Yeah, because the words are only securities and instruments.
Yeah.
Yeah, so the plain reading of the clause says that it's restricted, that these AIFs are allowed to invest in the securities. There's no specific restriction with respect to 10 or 24%.
Correct.
That's correct.
Thank you.
Can we get the next question?
Thank you. With the next question from the line of Kalpit Khandelwal from Fresh Associates. Please go ahead.
Hi, I have a question regarding the assured return and assured price. So if you refer to the definitions, the capital instrument, the explanation says that the equity shares should not have any option or right to exit at an assured price. And then when we just a second.
Yeah.
And then when we refer to the regulation 10, sub-regulation 7, that mentions that a person resident outside India holding capital instruments may exit without any assured return. So is there a difference between an assured price and an assured return? Keeping in mind the Tata Docomo case.
No, I think nothing has changed as far as the policy stand is concerned on this issue. As was prescribed earlier, RBI does not want any transaction by an equity investor where there is an assured price or an assured return that is promised. So whatever is the prevailing market price or FMV on the date of exit, as long as the put option is there, is at the FMV, that's the only type of option that is permitted. Any assured return or assured price options are not permitted.
Yeah.
So there is no change in the stance
It's
based on the
same
Tata
policy.
Docomo case.
It's the same stance. Yes.
It's the same policy as was the case earlier. There is no change in this.
Yeah, and I think the Tata Docomo case needs to be looked at in the context of what the Arbitration Act really says, right? It's a little bit more than just FEMA, because the Arbitration Act or a foreign award can only be challenged in certain circumstances, and that's how the Delhi High Court has interpreted it. So it's not necessarily, I mean, let's look at it as a whole instead of just instead of a specific. So I think it has to be looked at also with respect to Arbitration Act, as well as when a foreign award can be challenged.
Can we get the...
But the explanation, just a second, but the explanation to pricing guidelines, Regulation 10, Sub-Regulation 3, explanation says that the guiding principle would be that the person resident outside India is not guaranteed any assured exit price and shall exit at the price prevailing at the time of exit. So, there is no difference between a return and a price?
No, you cannot have any kind of assured return or any kind of assured price in these regulations.
Okay.
There is no change in that position.
And it means one and the same thing.
Same thing.
Yeah.
All right. Thank you.
I think the way to read that is, so if you have an assured price is a subset of assured return, I think it's been stated very clearly that whether it's percentage price, basically you can't give assured returns.
All right. Thank you all for Pratibha. Do you want to just give a word of thanks and we can conclude?
We just want to thank all the panelists as well as everybody who dialed in. We have over 100 people who dialed into the webinar. Just shows the importance of the topic. And so thank you everyone for staying on the call for so long. And to the extent that there are any unanswered questions or you have any further queries, please feel free to write to us on the email ID that Richard had mentioned before. Thank you everyone.
Thank you very much. Ladies and gentlemen, on behalf of Nishith Desai Associates, that concludes this conference. Thank you for joining us, and you may now disconnect your lines.